all of your questions, but we also want to provide the newest update information. And the two key updates that we want to provide is one, what happened at the interview that happened yesterday, where clients went for adjustment of status interview, came in as a tourist visa, changed status, what happened there. So there's a lot of good information we want to share. The second is the new AILA practice pointer that just dropped yesterday as well. Thank God for AILA for all the things that they provide. A lot of detailed analysis went into it. I know a lot of the good attorneys worked on this. So I want to share a lot of their practice pointers so you guys get firsthand information on what to do as well. And I'm here to answer any of your questions. Now, before we talk about it more, let me just give a big background, right? USCIS dropped a memo May 22nd, 21st, saying that as of now, immediately being implemented, people who are going through the adjustment of status process in the United States, people who are going into USCIS to do their green card application interviews, everyone, you need to prove why you didn't do it abroad, why they should approve your green card beyond your basic requirements. So everybody knows when you're filing for a green card in the United States, there's a list of requirements that you're supposed to meet. Well, on top of all of it, now there's this new additional one that you need to prove. And it's essentially saying getting a green card in the United States is an extraordinary privilege. Normal people should be doing it abroad, but if you're doing it here, you have this higher burden of proof. It is not a change in the law. It is just this discretionary measure where the officer can weigh the positive and the negative factors. So essentially, it's the government saying, if they really don't like your case, they don't like it, even if you meet the requirements by law, based on their discretion, they can still deny you and force you to reapply overseas. This is a big blow to many, many people who are in the United States. A lot of people are worried. A lot of people are concerned. And so this memo, plus what we're trying to share today, we're going to try to help out as much as possible, go as in-depth as possible. Normally, I do a short news segment and a longer success story segment. Today, I'm going to cut my success story really, really short. And I'm mainly focusing on this adjustment of status to try to help as many people as possible and go really in depth. We made several short videos to talk about this already to calm the nerves because this happened over the weekend. But today we really want to go in depth to kind of talk about it more. Now, before I do, just want to see if there's any questions I want to immediately address. But if not, I'm just going to directly jump into it. Okay, so first, what happened today, or no, what happened yesterday at the adjustment status interview? And of course, we had to ask the officers, did they see the memo? And they said they saw it. I was actually pretty surprised, right? I was pretty surprised that the officers knew about this memo, but it was so big, all over the news, I'm sure internally, I'm sure even if they're just on TikTok, Instagram, or on YouTube, they saw it as well. What is the internal processing for something like this? I could tell you immediately at these interviews, they're asking, why didn't you adjust back at home? Why are you doing it in the United States? They also ask, what was your intent when you first came into the US? And they ask, what touristy things did you do while you were on a tourist visa? Those three questions, I can almost guarantee every single adjustment of status officer is now asking. Now, if you were not on a tourist visa and then filing for adjustment, if you were on a TN visa, if you were on a L1A, L1B, H1B visa, they're probably not going to be asking these three specific questions. They might still ask, oh, why didn't you go abroad and do it? And if the answer is, well, because I'm working here, if I have to leave, it might take a long time. It'll be a disruption in the family. The company really needs me. I can take PTO. Those are probably sufficient. Now, I'll go in more depth for the people who already filed for their adjustment of status and they have interviews coming up in the next few months. I think a basic explanation with a few documents should more likely than not be sufficient, okay? Now, the reason for that is because these memos, when they go out, in order for them to actually implement it in a way where they're going to start denying cases, they're going to have to write out lengthy briefs and templates for all the officers across the country to copy and paste, right? If you think every single officer just starts with a blank canvas, adjudicates a case, and types out a long 3-page single-spaced denial, you'll be wrong. They spend about couple 10 seconds, 15 seconds, copy paste, switch out the names, modify a few things, and deny. So right now, there's no lengthy denial briefs that they can copy just yet. Now, maybe for a tourist visa, an ESTA visa, somebody who just came in unlawfully or lawfully, overstayed 90 days, filed for green card, and then they have no other ties. They have fraud on their DS 160. Maybe there's a template for that, right? Actually, I know there's a template for that because we've seen it. But usually it's connected with you have some problems with their case already where they want to deny you. And they will tag along this additional reason for denial where based on the positive and negative factors, they should just adjust status or cease. And the reason why it's easy to add that to a previous denial is because all the previous denial templates are already created. And now they just add this one little paragraph. And now they're shielded from lawsuits, right? Because if you want to sue them under the Administrative Procedures Act, you have to rule and you have to prove that the government administration made such an unreasonable decision. Any other officers would have approved it, but this officer made such a terrible decision. But now, if it's largely discretionary, if there's multiple reasons for denial, it makes lawsuits just that much more difficult. It makes motion to reopen and reconsider that much more difficult. So if you had a weak case, the template's ready for them to deny you, but it was a weak case already. If it's a strong case, as of now, and in the predictable month or 2 months, maybe they might not have the templates ready, and it's not as likely where you will get a denial just purely based on this alone. Meaning, if you came in as a tourist visa and then you adjusted status, and if you had an explanation, well, I was here, things happened, got married, wanted to stay, and there's all these things that I prepared for it. If there's a good enough reason, it's quite hard for an officer to still deny it within the next few months. That is what we predict. In the future, once they build out the templates, it will be harder and harder, and you need to build the case better and better. And we're going to go in detail to talk about what are all the things that you can prepare for. But I just wanted to share yesterday at the interview the 3 questions officers are immediately asking. Why did you choose to do adjustment of status in the US now? Why did you come to the US in the first place as a tourist? And what touristy activities did you do? They want to prove that you did not lie to the customs officer. So that's a new information I want to share. I want to go ahead and answer some questions.
Yeah, me and my wife just got married. We've been together for 3 years. I'm a US citizen, and she came in on an F1. So are we screwed? How is this memo going to affect us?
Great question. As an F1 international student, getting married, in the past you filed for adjustment of status, it should be an absolutely super clean case, right? Super straightforward. Now, if your interview is today, or in your case, it might be 6 months from now, the administration already had more time to prepare the denial. Now you really have to prove, well, why didn't you go abroad to do your green card processing? And so for international students who've been here and who've been dating for 3 years and then get married, your explanation might be, well, I've already been here for 3, 5, 6, 7, 8 years. I've been here since I was 14 years old. I've been here for an extremely long time. Back home, I actually don't have anything there. If I leave, I might have to quit my job. I have to be separated from my spouse, right? We've been together for so long. My spouse really needs me, you, right? Like, talk about your life. Well, you guys have kids, you guys have dogs. Right now, how do you divide up the chores? Without her, without him, it might be extremely difficult to navigate. Maybe you need, a lot of care, and she cares for you in certain ways. Leaving for a couple of years, disrupting your life is a pretty extraordinary circumstance. She's already been here for so long. She has nowhere to go back to. Some people's parents already passed away in their home country, right? So you want to talk about the country condition. You want to talk about your life here. You want to talk about circumstance. Talk about why not going back is so much more than just an inconvenience. It is not just I'm choosing AMC or another theater. And I'm not just choosing which path. It is a complete disruption of our financial life, our marriage life, everything. I have to quit my job. I have to take 6 months off. So for people who have been in the country on a different status, TN, F1, H1B, L1, you have a lot more that you can argue as opposed to you came in as a tourist for 90 days and you immediately applied for adjustment status. It makes those type of cases much more difficult to argue, but if you have been here for a long time, it's much easier to argue, so you can provide those arguments. It might not be enough. I mean, this memo goes a lot in depth, talking about all the different factors, positive and negative, that they're going to compare, right? So prepare your case well. In the past, your situation might have been a simple, straightforward application, but now just do that little bit more.
And yeah, I definitely want to get more into the positive and negative factors later. Another question, or this is more of a comment. We have too many B2 applicants coming to the US, essentially spouse shopping for a green card, which is hurting legitimate AOS applicants, and it's making a mockery of the system. So that's got to stop.
B1, B2 coming in, spouse shopping, clogging up adjustment of status interviews. Let's talk about the clog, okay? I mean, 400, 500,000 applications filed, every single year for adjustment of status, approximately, across the country?
400,000, right?
400,000, something like that. How many of these 450, 500,000 are from B1, B2 spouse shopping and then filing for adjustment of status? If I had to guess, probably less than 2%, in my opinion. 10% would be 40,000, right? Plus, it's probably nowhere near that. A lot of people might have already been married, came in, filed for adjustment of status. A lot of people have been dating, and then they came in and then filed for adjustment. They didn't come in to do the whole spouse shop. It is a little bit more convenient to do the adjustment status in the US compared to overseas, so some people choose to do it that way. But the majority of adjustment of status applications every single year, from EB1, from EB2, EB3, EB5, from people who have been in L1 and H1B approval, from people who, parent sponsorships, children sponsorships, ESTA, B1, B2 coming in, spouse shop file. I think it's, in my opinion, probably under 2%. So if something's under 2%, I really don't think it's much of a clog. The clog, if we want to really talk about clog, is when the US just wages war, every single year. Afghanistan withdrawal, Russia, Ukraine, the Iran situation, ad infinitum in the past 10 years. Every single time something like this happens, that is of the US's own doing, arguably, and you pull the I-130 and 45, that, my friend, causes clogs. And I know for a fact it clogs it because I go to these AILA conferences and I talk with officers and they say, yeah, sorry, half of our officers in our office got pulled to do this emergency situation. So we have less people to work on those cases. So that is the clog and not B1, B2. Now, do they, take up a few slots? Sure, but it's not much of a clog.
And if we're talking about hurting legitimate AOS applicants, this memo definitely...
This adjustment of status would definitely make their type of case, the B1, B2 shopping for a spouse filing, would definitely make it a lot harder for them. So, if your opinion is those people who come in and they get married should just not file for adjustment status, that should not even be availability, this memo definitely fulfills your wish.
How about entering with F1, then TPS to AOS with 245K based on EB3 approval?
I love it. I love all the acronyms.
Also, 39 country
ban. Oh, yeah. Shoot. That is extremely tricky. Well, because you're part of 39 country ban, I think that just kind of rules it off, right? So even if you file, just going to be pending forever. Now, let's just switch that fact pattern. Let's use the 75 country ban. Oh, wow, that makes it a lot more interesting. So let's talk about that, right? Because you have a lawful pathway to file for adjustment of status, right? Because the 245K qualifies you because you have a 180-day unlawful presence, you were able to file, you fulfill the legitimacy. This new memo just basically talks, why didn't you go back to your home country? Well, you have a ban in your home country. That's the reason, right? The 75 country ban, the 39 country ban, you have a ban to not be able to do it in your home country. You have to do it in the US. This is your only way, and you have been here. I feel like you have a really strong argument. However, the 75 country ban, the 39 country ban, a lot of it is trying to protect the United States. 75 country ban, you might not be rich enough. You might be a public charge if you come in the US. So even though you could do it legally in the United States, the adjustment status doesn't mean the officer wants to give it to you. So still go above and beyond and prove I'm not going to be a public charge. I have enough sufficient work, job, career, health to be able to make a living here. And I qualify in every single way. And this new memo, I'm also able to explain. So you should still be fine, right? Just do a good job.
Now, does this new law affect U visas? My brother's not sure if you should start the process.
U visas, you've been in the US for a long time. And if you start the process of U visa, you're not going to get your 45 interview until, I don't know, maybe a decade from now. So this new memo is not really going to affect you for the U visa. So just start the process, right? And if you're on the U visa track, there's very little other options for you. So you're basically, this is your only lifeboat. So don't let this memo or this administration or anything else dissuade you from your only life jacket.
Right. The memo like applies to them, but because they'll have so much time in the US, that's a positive factor.
Right. This memo really is not targeting U visas.
Can someone get a work permit even if they I-45 on admin close? So 485 has been admin closed.
Right. We have seen it. I don't know if it applies everyone everywhere, but we have seen it. I don't know the exact law regarding that. But for work permits, we have seen it routinely been given. Now, there's a lot of talk about like it was contractors that were issuing it, USCIS officers weren't issuing it, and so it's a way to game the system, or they don't care if you get the work permit because you're paying taxes, so they'd rather give it to you than not give it to you. And eventually, if they deny the 45, then they take it away from you. So there's a lot of talk and confusion about the work permit, myself included. But we have seen if you file the 45, you apply for the 765. A lot of times within a couple months, you get the work permit.
My husband has a deportation letter since 1997. I applied for citizenship. Can this be a delay?
His case will not affect your case on this matter. So you should still be able to get your citizenship, assuming you qualify for everything else. And then once you get it, then when you try to petition him and do the waiver, then it could go through. Now, if you're talking about how difficult will his waiver be? How long will it take? Does having a prior deportation order delay his waiver? Yes, right. Delay your petition? Yes, because then you have to apply for a waiver. But if your question is, will it affect your citizenship? No.
My OPT ends on 5/31, and my doctoral program starts on 6/8. My interview is on 6/15. Am I safe?
6/15, what kind of interview? Is it an adjustment status interview? Is it because you're on OPT? Did you already file for a green card application? Are you talking about your visa interview? Not quite sure what we're talking about.
If you do biometrics, fingerprint, in January, May 17th, they said they pulled my application. How?
You did a biometrics on May 17th.
I think in January.
Okay, in January. And then?
Then in May, they pulled their application.
What does that mean? Oh, I don't know what that means.
Will this AOS memo affect green card renewals?
No. This memo is purely for new adjustment status adjudication. It does not affect green card renewals.
When do you think the 75 country pause will end?
I think it's going to take another 2-3 years. I think it's going to go with this entire administration. They're not going to stop it. I think they might even add to it.
And will the 75 country pause affect... Oh, have you seen any medical exceptions get approved for immigrant visas from these 75 countries?
Other than they just added that you could do national interest waiver for doctors, right? Other than that, I haven't seen actual cases.
If you're on a conditional green card and you want to turn that into a permanent, will this new law affect you? Or this new policy memo?
Maybe. So if you are a conditional green card either through marriage or if you're a conditional green card through the EB-5 program, when you go for the 10-year green card, they may call you back in for an interview. And at that interview, they may go back and examine the whole thing. They shouldn't, but they might. And let's say you are the 2-year marriage one trying to go for the 10-year marriage one. And let's say you already got divorced and you're filing for a 751 waiver, and you came in as a tourist visa, and then you got married and you adjusted. This will definitely factor into that determination, right? Now, if you're an EB5 investor, as right now with all the other EB5 attorneys that we're talking about, it might affect it less because coming in as a tourist and then filing for EB5, investing $1 million, and then changing your life here, that might make sense because of the economic benefit to the United States, as well as how lengthy the process is for adjudication overseas. So you can make a strong argument why they had to do it on a tourist visa and why they changed their mind. But if your normal 751 application, you're still married, life is good, you have kids here, I don't think that's going to affect it.
I have DACA with military parole in place, married to a U.S. citizen, with AOS and 75 country pause. Will this memo affect me?
No, because you've been here for a long time, right? Compared to a lot of the other people who are like, why didn't you do it overseas, right? If I asked you, why didn't you do it overseas? You're like, well, I mean, where is overseas? Where is my home, right? Maybe I've never lived there, or when I lived there, I was really young, and my work is here. I have military parole. I have all these other things. Abandoning everything to go back home is an extraordinary feat, right? So, for the people who've been here for a long time, this memo doesn't affect them that much.
Right, affects them, but they have mitigating factors.
Yeah.
My Pakistani spouse is on visa pause. Can he work in a different country while waiting?
Yes. You can apply for any other country. The U.S. memos only affect the U.S. countries.
Can you help with H-3 visa petitions?
I don't think so. We haven't done one in a long, long time. And right now, we are at maximum capacity in all departments. So it's really hard for us to do something new right now.
Will this memo affect marriage green cards in the U.S.?
Yes. So a lot of it is, the people who are affected the most are probably the people who came in on an ESTA, a visa waiver, and then got married and filing for adjustment, or came in as a tourist visa and then filing adjustment of status. And a lot of them are marriage, or a lot of them are like parents or sibling petitions. So, but if you ask, marriage petitions, adjustment of status in the U.S., yes. Now, if you've been here for a long time, you're on DACA, and then you filed, probably less so of a effect. You have a lot more mitigating factors, a lot more explanation that you can do.
I'm on F1 STEM OPT, marrying a U.S. citizen with no unauthorized work, 7 years in the U.S., 5-year relationship. And I have worked for the DoD, a lot of citations in the STEM field.
Great.
Okay. Now, what are my chances with AOS for marriage, or is it better that I file for EB2 and IW?
Your chance of, well, let me put it this way. You listed out your achievements and citations and your security clearances, which is all great. You probably have a shot at NIW EB2. I'm not questioning you on that. You probably have a really good plan. However, when you want to compare that to marriage, usually marriage should be a pretty slam dunk application, assuming the other person is a nice counterpart to you. You guys are a match. But without knowing more about your marital situation, it's hard for anybody to really comment on it. For example, let's say your spouse was a homeless person you picked up from the streets. Any officer doing a security clearance check, they're susceptible to a bribe, your marriage is fraudulent, they will deny you. But assuming socioeconomic status, language proficiency, education, socioeconomics, you guys are a match, you guys look compatible, there's no huge factors, right? If you're a girl, you're not like 20 years older than him, right? If he's 20 years older than you, yeah, I mean, sadly say society is okay with that, right? And so there's different things that you want to match. But if assuming the marriage is good, your marriage case should be totally fine.
Right. And for AOS specifically.
Right. So if you got married, file for adjustment status based on the marriage, should be fine.
Mm-hmm. My green card application says ready for interview, but I've been waiting 8 months for this interview. Is that normal? What should I do?
Contact Emma, which is the online chatbot for USCIS. Call USCIS. It's really annoying. It's probably the worst thing you've ever experienced. Do that. You get a tier 2 officer. Have them try to push the interview faster. And if that still doesn't work, do info pass appointment. Go in person to push them to do it faster. Maybe they lost your file. These are things that you could try to do.
So yeah, feel free, everyone, to ask questions just in the chat, and I'll read them out in the order we get them. My girlfriend is DACA and owes back taxes. Will that affect approval?
Yes. Yes. USCIS, during the adjustment of status application, review positive and negative factors. And one of the things they care a lot about is tax liens. Do you owe any taxes? So definitely get that all paid off. And then do everything you can to improve the chance of success, right? So holding down a job, a W-2 job, having a really good-looking tax return, showing your financial ability to support each other, your life here in the US, having no criminal records or having things, having the probation all done, dismissed, and do charity, volunteer. There's so many things that you could try to improve. But if you owe back taxes, it's definitely a huge negativity for the officer.
Thoughts on AOS based on approved asylum?
This memo doesn't affect the asylum group as much. In fact, if you came in as a refugee, which is different than asylum, you have a higher chance. I mean, not even a higher chance. This memo just straight up doesn't even apply to you, right? Because this memo applies to all discretionary adjustment of status cases. But there are certain cases, I think like Cubans and certain people.
Haitians. Cubans are.
Oh, Cubans are. Okay.
Yeah, it's the ALA policy.
There's you know what? I have it here. ALA policy. There are certain groups that are non-discretionary, and refugee is one of them. And so, very similarly, if you're on asylum, that's the whole idea. You came here, you're fleeing your country, you can't go back to your home country, right? That's why you're doing adjustment of status here. So, if asylum is approved, this memo really is not something you need to worry about.
So, can my Pakistani spouse, who's waiting on the 75-country ban, can he work in any other country or just his neighboring countries?
I don't know, but I'm assuming you have to have work authorization to work in those countries. But I mean, to the U.S. it doesn't matter, right? So work, prepare yourself, prove that you have financial ability, and then once the ban is lifted, you go back to the interview, you get the visa, then you come here, right?
My pending concurrent green card filing is going on 19 months. Is that normal? When should I expect it?
Most green card applications we see is around 10, 11 months, but sometimes things are a little bit longer. USCIS has a huge backlog. 13 months, it's not completely out of the extraordinary. I would definitely do your due process to do the Emma, to do the phone call, to push them so it has a record of you trying to push for the case. They might move it a little bit faster, but if it's way too long and you can't wait anymore, then get your Congress involved to try to make it go faster, or you have to sue them to make it go faster. But yeah, 13 months, I think, it's still USCIS. They'll probably tell you it's still within their processing because everything is slow, right? But that's not actually a legal response in the sense of it used to be faster. You just made it slow. So it's your fault, right? You can't just say, oh, I'm just really slow now, right? Well, then you need to get your act together, right? So we've sued over that response, saying, you can't just say it's not beyond processing time.
Okay. Is change of status to H-1B cap exempt in the US affected?
Not from this memo, but from a previous memo, it is, right? If you're on a tourist or if you're on any sort of status and you're changing status to another non-immigrant visa, B1, B2 to H1, H1 back to B1, B2, it's all discretionary now. And this memo really is just saying officers have a lot of discretionary power. So in a sense, it's both the same thing, but the previous memo applies to change of status. This memo applies to adjustment of status.
Will this affect SIGIS or SIJ with approved deferred action waiting for their date to become current?
I don't think so, because if you are on SIGIS, right, Special Immigrant Juvenile, you are here in the United States, there's a reason why you're here by yourself. Maybe your parents have abandoned you, maybe there's some sort of situation. It's a very delicate situation, right? So you can't go back to your home country. So this memo, you just want to explain, hey, why didn't you do it overseas? Well, the fact that they are going through the CIGIS program kind of sort of self-explains why they couldn't go back to their home country.
What if I'm on a J1, which is single intent specifically?
Sure.
And my husband is a U.S. citizen in the Army. He wants me to do the adjustment.
Sure. Provide an explanation. Why don't you want to go back, right? So J1 is not different than F1, not different than any other category. So explain, well, I've been here for so long now. If I had to leave, we had to sell the house. We had to, we have to transfer the cat and the dogs back. We have to do all these things. It's extremely disruptive to our life.
Okay, and I want to get into the positive and negative factors because I think that's really central to how they're going to adjudicate. So we have a list in the AILA policy memo.
Yeah.
This, if you're thinking about like how much will this memo affect me? I think the positive and negative factors is worth looking at.
Let's do it. So this is AILA document number 260-52602. Again, it's AILA number 260-52602. You can just Google that. You can find the information. Maybe AI is even able to summarize it for you. Here are the negative factors I'm going to read out. Violations of immigration law or conditions of a prior status. That's really important because let's say you were a student, but you were working on the side. That's a violation of your prior status, right? So violations of immigration law or conditions of your prior status. Number 2, fraud or false testimony in dealing with USCIS or any government agency. Doesn't matter if it's just U.S. agency. Doesn't matter if it's just a consulate. Any agency. So Medicare, Medi-Cal, agencies overseas. You have another visa denial from Australia, from Canada. Those all now matter a lot more. Conduct inconsistent with the purpose of the non-immigrant or parole status. So let's say you came in as a tourist visa. Within 90 days, you filed for adjustment status. You came in, you were supposed to be a tourist, but why did you immediately get married and adjust status? You came in as a tourist, but why did you quit your job overseas? You came in as a tourist, but how come all this money was being wired into your bank account the moment you got in? Are you transferring all your assets over? Conduct inconsistent with the purpose of your non-immigrant parole or status. So, well, that seems like you intentionally lied to an immigration officer. That is false representation. So we're going to deny your adjustment of status. Failure to depart when the purpose of an admission or parole was accomplished. So you had your purpose in being a tourist here. We granted you 90 days. We granted you 6 months. You went to Disneyland the first week. But then why did you continue to stay? You told the officer you're only here for 2 weeks, right? But how come you ended up staying and you got married the 3rd week and then you ended up filing for adjustment on the 90-day mark exactly? Show me what you did. Let me see your phone. Let me see all your activities, right? How come you applied for a job on the 5th week here as a tourist? That seems very questionable, right? Applying for adjustment of status in a category where consular processing is available. You clearly could do it back at home. Why did you do it here and do it now? Are you trying to cut the line? Are you trying to do something, right? That's inconsistent. Intent to circumvent ordinary consular processing. So again, preconceived intent and choosing not to do consular processing for a purpose. These are all negative factors that they're looking into. Positive factors, your family ties to the U.S., your good moral character, the national interests that you are afforded, right? So the economic benefit of you doing adjustment status in the United States. If you had to do it in the consulate, the U.S. will lose out on some key benefits. So you get a benefit, the U.S. wants some of that dough also, right? So why does the U.S. benefit? That's why for a lot of EB-5 individuals, if they had to do consular processing, they might have to wait an additional 2, 3, 4 years. And that would discourage a lot of people from doing the B1, B2 to adjustment of status, and they won't invest $1 million. The U.S. needs the money. So everybody else still coming in, still doing the EB-5, but now you have to prepare that explanation in your 45 application, right? So other positive factors, long-term lawful presence in the community, right? You've been a student, you've been an employee, you've been working, you have tax returns, you have civic involvement, you have evidence of good moral character, you have no criminal history, you have charitable contributions, you have professional accomplishments, you've demonstrated a benefit to the United States with your employer sponsorship, with your specialized skills and your economic contributions. These are all good things that outweigh the bad things. at the end of the day, it's up to the officer to decide what is actually does that weigh scale mean. So in the past, didn't have to do that much, right? I qualify for adjustment of status. I got married to a U.S. citizen. I have no criminal record. I get a green card. It was a simple application. It's it's tedious. You have an interview, but relatively, it's just paperwork. Now there's persuasion involved. Now there's actually documents you have to prove, and there's discretion. There's much more discretion. So a lot more uncertainty. In a time that is already extremely uncertain, it's not great, but this is the way the government pulls back power from the people so that they have more power, so that they could deny cases much easier. They can force people to do it overseas where they have absolutely no oversight. So if the consulate denies a case, you can't appeal it. That is what the government is doing, for better or for worse. That is their choice.
Okay. So here's one example that I think we can like weigh the factors on.
Yeah.
So I'm about to file for AOS. I'm from the UK, got married to a US citizen in February. No criminal record, no like red flags like that. I came to the US 70 days ago on ESTA with no intent to stay, but my significant other had some medical issues which got serious, and now her doctor recommends she as a primary caregiver, which presumably they want to become. So is this likely to become an interview? Should I try to show positive equity to the United States? Can we get married in the UK? Oh, we got married in the UK and we came to the US to celebrate the wedding with her family.
So one thing I want to mention that you may or may not know about is that when you come in as an ESTA, you voluntarily waived your right to do a lot of immigration processing. Meaning, if your case does get denied, ICE can detain you and you could be in detention and you cannot get bond. That was always the case, almost never enforced until what we saw this year. And it comes as a huge shock to the immigration community. And that is the first thing I want to say. You might say, that's outrageous. That is impossible. It's a split court decision, meaning if you're in California and you're in the Ninth Circuit, you might be fine, but other districts, you may not be. So definitely double check. And that is just additional risk that you have to go through. Because if you file for adjustment of status, and in the end, if the officer denies you, if you're in an unfavorable district, an NTA, notice of intent to appear, might be issued to you, but at the same time, you might be handcuffed and taken to detention. This already happened to somebody from Ireland, so part of the United Kingdom as well, right? And now, to your specific question, you came in as an ESTA, you change your mind, you want to file for adjustment of status. Medical reason is very strong. Presumably, you guys been living in the UK before, so document things like, well, we both had our jobs still. We didn't quit our jobs. The medical condition happened. Now we had to force to resign. The family is here. We weren't preparing to live here. We were still, we still had a lease. We didn't cancel the lease. Everything was still ongoing. But now we have to come and we have to do all of this now, right? So you want to document your intent very, very clearly. But at the same time, you want to prove your marriage is extremely strong and why you're doing it here and why you're going to stay here. The jobs that you have, the work that you can get, the family support, all of that needs to be super well-founded. But yeah, that's sort of the big idea.
Will this memo make it hard for F1 who's on day CPT to apply for adjustment?
Day one CPT schools are not looked at favorably by USCIS officers. So if you think about that as a red flag by itself, and then if the rest of your adjustment status case is really weak, now you sort of have two things against you. But again, if you are on day one CPT, presumably you had a normal F1, meaning normally you've already been here for a long time. So if you've been here for 4 years, 5 years, 10 years, and then this memo is saying, why didn't you go back to your home country? It's not that hard to explain why you can't leave. But if you're on a day one CPT school, the school is not that important. You're not making that much in the US and you have family abroad. If you had urgent reasons and if you're constantly traveling back and forth anyways, it might weaken your reason why you have to do it in the U.S. Right? So just small detractor. I wouldn't say it's overwhelmingly kills the case, but the rest of your case should be strong.
What about F1 student adjusting green card to a husband who's in the military?
F1 status, got married to a military personnel. I'm assuming the military personnel is stationed abroad, so you guys are not together. So the question is, why can't you go back to your home country, go through a consular process, and come back? Well, one potential argument is who's going to take care of the house, the cat, the dog, the fish, right? Military spouse is abroad, grandparents are not here, or there's nobody else here. I can't ship everything back. The quarantine is going to be like 9 months. Maybe, that's an explanation.
I have I-140 and a visa currently. Can IJAOS at individual hearing while has asylum after new memo?
Oh, I would really recommend contacting an asylum specialist that do that. Our office doesn't do any asylum applications, so that's much harder for me to answer.
What is that rotating thing on the left? I want it.
It's a globe of the Earth that is powered by the light. So the magnetic field is so it's receiving power from energy from the light, and it syncs with the gravitational pull of the Earth, and so it's spinning as our Earth spins. Pretty cool. Got it as a gift. We have a couple of these.
Just like the real Earth.
Yes.
What about people filing for citizenship? What affects us?
The memo that applies to citizenship application, there were 6 that dropped last year, and the most important one, in my opinion, is the one on August 25th, I believe, and it's basically talking about the good moral character. So on top of the physical presence, the continuous presence, and everything else, they really upped the good moral character standard. Up it or clarified it. Before it was just, I have no criminal records, therefore approve me, right? I'm a good person, I have no criminal records. Now, that's not good enough. Now they go into all these other things, including your transcript, your grades, your education. Does that mean if you have a low SAT score? Does that mean if you have low, grades, you're not a good person? It's bizarre. But check out that memo. That applies to citizenship applications. And we did a whole dedicated video on that too. Several videos on that.
I will be coming to the US using my valid B2 visa, as the same employer who sponsored my H-1B back in 2017 has offered me a job. Is it possible to renew my existing H-1B visa once I'm back in the United States?
So what you're talking about is you come in as a tourist, and then after 90 days, you do a change of status to H-1B. Because you're doing it in the United States, you're not legally required to pay the $100,000 fee for the H-1B. But this U.S. officer who's reviewing your case might be extremely suspicious that the entire intent of you coming in as a B1, B2 is just to skip that $100,000 fee. And so they might deny the case or approve the case, but force you to go back to the consulate, so making you pay the $100,000 to do consulate abroad. But then after you pay the $100,000 and you go abroad, the consular officer reviewing your case might be extremely pissed off that you even tried this whole method, and so deny your H-1B visa. Just saying that's possible. Now, in the past, B1, B2 changed to H-1B. Done it plenty of times. Not horribly difficult. You fulfill the requirements, you prove it, case approved. Now it's discretionary. Now there's that $100,000 fee. Now there's a lot of other concerns that you have to factor in. So we're not really recommending it. I'm sure there are courageous firms and clients who have tried it. I don't know what the success rate is. We haven't done it yet. Just want to put the warning out there that is a high potential.
For naturalization, I have 3 traffic tickets that got dismissed and 1 auto accident with no alcohol involved. Am I good?
I don't think that's a big negativity, right? So if you've held down a job, if you have family, if you've lived here for a long time, and that's like the minor thing, and everything else looks great, I think you should still be able to get the citizenship.
For marriage adjustment, we were doing consular processing, but after the I-130 got approved, we changed to AOS because of the wife's mental health.
Okay.
Thoughts? Is this going to be affected by the memo?
So you've already filed in the past. So therefore, now if your interview is coming up in the next few months, you should be prepared to explain why you ended up changing, why you have to stay in the U.S., why it's so important, and why you didn't. You did what you were supposed to do, right? You came in as a tourist, you did your touristy things, and then there was a major circumstance that changed and it caused you to change this plan, and you filed.
My I-130 was approved. Bona fide marriage, true marriage. Does this memo still affect me?
If you want to do adjustment of status in the United States and you don't have a non-immigrant status in the United States yet, right? So if your I-130 is approved, but if you need to come in as a tourist visa and then to do adjustment status, this memo will affect you a lot. If you've already been in the US for a lot of other things, this memo affects you a lot less.
My OPT ends on 5/31, and my doctoral program starts 6/8.
Okay.
My AOS interview
Okay.
is 1 week later. Am I safe?
From this memo. So this memo will ask you, well, why don't you go back? And your explanation is, well, I can't give up my doctorate degree, right? It's too important. There's too many things I have to do here. And line it up for the officer, right? Not just your interview, but when's the next publication? When's the next conference? When's the next, school interview? When's the next project? When's the deadline for the next thing? Come up with like 10 different deadlines the next 10 months. That's why I can't go back. What am I going to go back to my hometown for, right? There's nothing for me to do there. I've been here for 10, 15 years. That's why.
I'm an F1 student. I have I-140 EB2 NAW approved and 485 pending. No overstay, unauthorized work, or criminal record. My visa will expire in July 2027. How will this AOS memo affect me, and how should I prepare? I entered in 2022 as a PhD, and I'm on a 75 country ban.
Well, if you're on 75 country ban, your goal is to try to get another non-immigrant visa to come to the US.
They're already in the US on an F1.
Oh, okay.
And they're going to EB2 NAW.
Oh, okay. Well, then once that all gets approved, then you file for adjustment status and you show that you cannot come to the US or you cannot leave because you have the 75 country ban and therefore you qualify, right? So this memo doesn't really affect you that much.
Right. Also, there's a national interest exemption from this memo. And if they're going to EB2 NAW, you think that's an easy argument to make?
Yes.
Since China doesn't recognize gay marriages, can my boyfriend still move to the US since the US does?
Because China doesn't recognize it, can they move to the US? Yeah. So you come in as a tourist, you get married, but you still need to explain why you didn't do the consular processing, because you could still go back and go to the US consulate to go for that interview, right? So that by itself doesn't explain why you have to do adjustment status in the US. Now, if you explain, well, I can't go back to my home country, 6 months, 9 months, I might be persecuted. I'm not trying to apply for asylum or anything, but I'm just saying my family doesn't accept me, my community doesn't accept me, I'll be separated, I'll have anxiety. So that's why I moved here. And then, it was just supposed to be a tourist visa. I'm just supposed to visit for, a couple months, but then all these things happened and it's just so much more important for me to be here to adjust. You have to come up with a really good argument. But if it's just purely, China doesn't recognize gay marriage, therefore I'm going to adjust status in the US, that by itself doesn't quite connect.
I overstayed on a visitor visa, and now I'm married to someone in the Army. Can I adjust status?
You can, but then the officer is going to review and say, why don't you do it abroad, right? If he's in the military, if he's stationed abroad, you could still leave and just do adjustment overseas. Why do you have to do it here? So you still have to answer that question. So this memo does affect you a lot.
If a 19-year-old does not want to give a letter for a detainee dad, would that affect anything?
For the 19-year-old?
Or for the detainee dad?
Well, the detainee dad needs strong equity to get out. So if the detainee dad doesn't get the equity that he needs for ICE, for the immigration judge to approve in his favor, then he can't get out.
If my mom is a Canadian citizen, I'm a U.S. citizen, I want to file for her. She's still in Canada. Can she file for AOS here, or should we do consular processing?
So normally you should do consular processing, right? So if she does want to come here and then file for adjustment, there needs to be a really strong reason why. But all things considered, probably best to do the I-130 and the consular processing abroad.
Persons on ESTA, do they get to see immigration judges? I thought they don't because they waive that right using the visa waiver program.
You're right. They are, well, so what I'm saying is, so somebody comes in on ESTA, overstays, files for something, doesn't matter anything, files for something, adjustment status usually, gets denied, and then ICE picks them up, and then now they're pulled into detention. If you try to get bond in a jurisdiction that doesn't allow for that, so I think the 9th District in California, etc., allows for it, but if you're in a district that doesn't allow for it, and you try to apply for bond, they will deny it. You can still request an immigration judge. The immigration judge could still deny it. You are still going through removal proceedings, right? So you waive a lot of the rights. You could still petition for it. It becomes a lot weaker, right? Again, this was rarely enforced prior to this year, but now we're seeing it happen.
How long does it take for K1 visas with a change of status to get a green card and work permit?
K1 to work permits, I think it's about 4 to 6 months. And then the green card itself is about a year after you file the case. That's the timeline I think we've been recently seeing. That's assuming you already got the K1 I-129F approved, you got it consulate approved, you came in and then you applied, and then you got married and you applied for adjustment status.
I'm an F1 student, then OPT, now asylum seeker, but married to a U.S. citizen. Can I still adjust status?
Yes, but now your burden of proof is a lot higher. It's not, everybody else only has to prove 50-50, right? Your marriage is 50% real, right? I believe you 50%. Yours is like 95, 98%, right? You have to do clear and convincing argument. So, that's a lot of things to prove to clearly demonstrate your marriage is real. But you can still file. And if it gets approved, you still get it through the normal processing. But if it's denied, you go through immigration court and you have to prove it there.
For this Canadian mom, will the 75 country ban affect her?
Is she also a different citizenship other than Canadian? Is she like from Iran or something?
But either way, right? Canadian citizen, the dual national overrides that?
Oh, yeah, that's right. That's right. But we have seen somebody who overrides that, but still stuck in the consular processing for like 2-3 years. They're 2 years now. So it's tough.
Another came in 2020 for a PhD. Now they're on OPT and they want to go to EB2 and a W.
Yep.
Yeah. How much are they affected by this memo?
Not as much, because you've been here for so long. You have EB2, EB3. You're going to adjust status based on that later on. This memo wants you to explain why don't you do it back in your home country. You haven't been home for a long, long time. Your U.S. job is very important. So you have a pretty good explanation.
And I want to talk a little bit about how we are thinking about this memo in terms of how we're preparing cases going forward.
So all the cases we're doing now immediately, we're adding that argument, right?
Which argument?
The why they are choosing the U.S. as opposed to overseas. Now we're doing that for basically the next couple weeks. All the ones that we have already been preparing and we're ready to file, we prepare that. In the future, if it's a strong case, we'll do the same thing. We'll add that little argumentation. If it's a really weak case, we will build up a whole brief to prepare for that. We might still only include partially, but we'll prepare it beforehand so the client is ready for that at the interview. And we will treat this as an additional red flag. So based on our firm, the way we process a lot of things, we analyze every single case and we will quote a fee and a plan depending on how many red flags it has. So if a case has one red flag, it's very different way to process and prepare and strategize compared to somebody who has four red flags. So this in the future is one additional red flag, and we will have to prepare accordingly, right? A new additional arguments, new additional exhibits that we have to go through and prepare for. And so they will apply to almost every ESTA and B1, B2 cases if they're doing that and doing marriage adjustment. So it's just additional thing that people have to really prepare for.
How much do you charge to respond to RFEs or to help with drafting a clear, convincing argument if I provide the facts?
The best we can do is the 250 consultation. I think we are able to help so many people through that. Today I'm doing 6 consultations. Tomorrow I'm doing 6. In our firm, every day we probably do over 12. These consultations are not sales calls. We're not trying to take in the case. Our goal is to give you the most value in that 250 consultation. So let us know what questions you have, how we can help you. You're smart. We're smart. Let us know how we can help you within that hour, right? Share a screen, tell us your argument, we pick it apart. We could do so much within that hour. And I've helped people win crazy cases within the hour. Now, there are some things that just way beyond what we can possibly do for an hour. Something that will take a whole year of preparation. Well, at least once we analyze it, we can potentially quote you, hey, if we want to do this, this is how much it will cost in the next 3 months, 6 months, a year, right? So we'll give you a quote, but the goal is not to take in cases. The goal during that consultation to help as much as possible. So if you have a good argument already, draft it out, have the exhibits ready, jump on a call, I'll pretend I'm an officer, and we kind of just brainstorm together.
Is it possible to get initial OPT nowadays? If I have crime history in Oklahoma, I have a deferred sentence fully expunged and dismissed, pled no contest, did simple classes for simple assault and battery.
I'm not sure. I haven't done a case like that in a long time. In the past, applying for OPT work permit, I don't think it had a lot of scrutiny for 765 applications. But in the future, it is getting more strict. So I do foresee there might be potential pushback where they don't issue these work permits, but I haven't seen it yet.
Will this memo affect VAWA cases?
Yes, in the sense of, let's say you were a tourist, you came in, you got married, you got battered by your spouse, and now you're filing for a VAWA case. Well, it goes back to, well, why did you come into the country in the first place, right? So there's a lot more discretion. Now, part of VAWA and part of how we prepare VAWA is we want to prove that you really want to be here and the US is very important to you, right? And VAWA overseas is extremely difficult. And so you want to prepare that explanation well, and that's part of the positive equity that this memo kind of provides for.
Okay, we'll answer a couple more questions and then end.
What time is it?
It is 1:04.
Oh. Let's do 2 more questions, and I want to jump into a quick success story as well.
Okay, so we'll do 2 more questions. Does K1 visa need a separate work permit? Why aren't they allowed to work with just a visa stamp similar to L2 spouse?
For your reference, L2, E2, H4, dependents being able to work, O3, has always been a major contest in the United States Congress. And it took a lot of fighting for L2, E2 to be able to get it. But most people don't have it. So if your question is, why is it an issue? Because the US government just doesn't want to give out work permits. If you're asking why do other visa categories get it, but we don't, it's because they are higher priority. They like them more. Will one day immigration law change? Maybe. Not likely. With this memo, it practically in a semi-way cancels out K1 and K3 visas, but not really. But it's just, K1, K3 is kind of going downhill. So it's not very likely that they're going to do a congressional change on that. So that's my answer to how come I can't get it when other people can.
Married to someone in the Army in the US, your country's on the 75 ban list. can you adjust?
Yes, you can. 75 country ban only bans overseas. You're in the US. You can file adjustment. This memo does apply to you, so you still want to prepare a really good explanation as to why you're doing adjustment of status. But the 75 country ban might actually inadvertently help you in a way, right? So those are all the questions I can do today. I do want to jump into a quick 1-minute success story. I just really want to report that yesterday I was able to go to Mexico, pick up a client, bring them into the US. They're a green card holder that's been out of the country for 7.5 years. They left the country in 2018. They filed for a reentry permit. It expired in 2020. Their green card expired in like 2021 or 2022, something like that. And they've been out. We filed the I-90. Even though it got approved, the 3-year extension is still, it passed. So their I-90 extension is passed. Their green card is expired. They've been out of the country for 7.5, 5 years. Their reentry permit is expired. I was able to gather all the documents. I went down to Mexico to talk to an officer for 9 times this past entire year, and we were able to succeed. And there are 2 reasons why it worked. Number one, we were able to successfully get a 551 application approved. So he had that application in hand. And the second is because we were able to fully explain why he was stuck overseas for 7.5 years. And we only used one reason. And the reason was because he was in a civil litigation trial and his passport could not be issued, so he couldn't leave the country. There was a really hard decision. Do we say it? Do we not say it? Do we say it? Do we not say it? But we were able to prepare it, explain it well. The officer understands, saw the 551, saw the explanation, saw us preparing for a whole year, and approved it. It was a very strict interview. And while driving back from Mexico, I made a whole video on it. We'll probably post it, maybe early next week. But just wanted to share that good news. If your green card is expired, if you left the country for over a year and you're concerned about getting back, it's still possible. Don't abandon it too quickly. Let's try first. Okay? Thank you, guys. I know it's a hard time. See you guys next week.
Thank you, everyone. And how can they book with Joseph if they want to?
The best way to do it, go online, go on our website, the consultation page, just make the payment, book like a couple weeks in advance. Doesn't matter which category you choose. Book it, and then in the booking notes, just write, I only want to talk to Joseph, and this is why. And then we'll have somebody contact you to kind of coordinate the schedule. Our website and our consultation format is designed to help people immediately and as fast as possible. That's why we have a lot of openings, but it's not all with me, right? My team is really good. They're all better than me. I don't think they're all better than me, but they're all really good, and they're all better than at me in certain ways, right? I'm good at some things. They're good at other things. And we want to help as many people as we can possibly can, as fast as possible, because these are time sensitive. But if your case is not super time sensitive and you're willing to wait a couple of weeks, then just, go ahead and do that, book, and just say you only want to speak to Joseph, and we'll talk to you then. All right?
Thank you, everyone. We will see you all next week.